Hello, this is Maria Hernandez. I'm the presiding judge here in Orange County, California. That's from Southern California. Reaching out to you and saying, first of all, thank you for letting me have an opportunity to share a little bit with you about one of our new innovative statutory programs referred to as the CARE Act, which is the Community Assistance, Recovery, and Empowerment Act. It originated out of Senate Bill or SB 1338. And I'm going to spend a few minutes with you going over the act itself. I'd like to share with you how we implemented the program, what we did collaboratively to work together to create the infrastructure, where we're going, and 6 months later, some of the assessments and the evaluations of what has transpired. But to share just a little bit about myself as I talk with you about the CARE Act, I am a judge here who oversees many of our collaborative treatment program in courts in Orange County, California. But really importantly, I've been involved in treatment courts or collaborative courts, as we fondly refer to them, for about 35 years. First as a public defender, and then when I took the bench in 2006. So this is something that is near and dear to me and something I'm really proud to be a part of. And what I'd like to say again is thank you for allowing me to share and seeing the cross-sectionality of the participants in this conference here just reminds me how important our collaborative work is together, seeking innovative programs, treatments, and plans to make sure that we see better outcomes for the community that we serve. So with that, let me talk to you a little bit about the CARE Act itself, what it is and what it is not. It is a civil court process, and I will share with you, I've been involved in many collaborative treatment courts that originate and are housed within the criminal justice system and addressing various areas, whether that be a drug court or mental health diversion courts, any of the other mental health treatment courts that we have. But this is a very different program. This act is housed within our civil court system. So what we want to make sure we're sharing today, as well as what we've been sharing for the last year to 18 months, is this is not a criminal procedure. And in fact, we want to intervene and intercept so that we don't find people in the criminal justice system, which I believe is really important to you when I look at the agenda and what you are going to be going over in the next couple days. Our CARE Act here in California is anywhere from 1 to 2 years in its process. As I've shared with you, it is not a criminal court. And one thing I want to share with you up front is it is not the end-all be-all solution to homelessness. And that is some of the information that we really had to get out to our community. And even today, as we move forward with the program itself, something that we want to make certain that, of course, we want to look at the needs, high risk, high needs. But again, this is not the end-all be-all solution to homelessness in California. And very important for everyone to understand, CARE Act and CARE Court is voluntary and it is not punitive. So we're going to talk about some of the practitioners, about when this legislation was first enacted, and prior to its enactment and the chaptering of the bill, there was a tremendous amount of resistance, concerns from advocates, mental health advocates, that this would take away the dignity, the independence of those who are mentally ill. And I want to make certain here in Orange County and California, this is not punitive, and this was not intended and is not intended to cause taking away of those civil rights and those concerns by our mental health professionals, as well as the individuals and their family members. One of the other things that we want to talk about is that we work very collaboratively with our behavioral health department, and you'll hear me speak throughout the remainder of this session about the collaboration between all of the partners and stakeholders that are involved in this particular act. And you'll also hear me refer to it as the CARE Act, although it sits in the court and we talk about the court. We learned very early on in many of our community outreach town halls that family members and those of the individuals who will participate in this CARE Act don't want it referred to as a court program. It has an overreaching thought of being involuntary when we talk about court enforcement, when this is actually a way for the court to convene parties and bring them together in a voluntary process. So a little bit to go back to, where did the CARE Act come from? Senate bill, as I indicated, SB 1338, was chaptered September 14th, 2022. It resides in what we call our California Welfare and Institution Code under the 5970 section. What was set out in that legislation early on is there would be 7 cohort original counties, what we call our cohort 1 counties, who would be required to implement this program by October 1st of 2023. Additionally, Los Angeles County, and many of you will know, Los Angeles is like a state in and of itself in light of its size. It came on earlier than the next cohort 2 county and joined with cohort 1. So we have 8 counties that by the end of 2023 were in full implementation of the CARE Act. What we want to talk a little bit about, so that you're aware of some of the heavy lifts that we had when we knew this legislation was coming down. As a court, clearly we want to interact, we want to collaborate with partners, stakeholders, our RAP services, our behavioral health partners. So it was really important, as we saw this legislation making its way through the chambers, that we were prepared for it. In Orange County, as I shared with you first on, I sit as the presiding judge. We knew it was important that we were a part of this cohort 1 counties because we wanted to be able to help form what this program and what this infrastructure would look like. And we wanted to make sure we started messaging to our community providers, to those who would be utilizing this program, what CARE Act is and what it is not. Which meant we continued with our conversations from the minute we saw that it was hitting through the legislature till it was chaptered on September 14th back in 2022. And that gave us roughly a year to create a program from ground zero with all of the rules, the forms, and making sure that we were reaching out to our communities and educating, and also working very closely with those who had resistance to this program. Again, I spoke about those early on, which is there are some groups that still hold a strong resistance to the implementation of the CARE Act. We want them at the table with us. We continue to bring them to the table to have very robust discussions about what is a better way that we can deal with the participants and alleviate some of the concerns that they have about taking away their independence and their dignity as they move forward through the process. So this is one of the charts that I like to share. We put this out there when we talk with all of our stakeholders. And more importantly, we probably had about a dozen, what we called them, town hall meetings throughout our entire county to make sure we addressed our population that we serve, and specifically addressing those who are coming towards us and saying, we need help, but we don't know how to find it. So this was kind of our bullet point that we put out there as what is court? What is the CARE Court? It's a new civil court process. It focuses on our county and other local governments on serving persons with untreated schizophrenia spectrum or other psychotic disorders. What we saw very early on was so many wanted that expanded, that criteria that's expanded, and we'll go into a little more detail about some of the specific criteria. But very important was to be able to share with them that this legislation does have very specific criteria that addresses the high risk, high need individuals who have untreated schizophrenia spectrum or other psychotic disorders. It does not cover bipolar disorders. It does not cover depression. It does not cover all of the others that we talk about that we know there's a need to address, but this is very specific. And there were numbers, at least in California, that addressed, how many thousands of people are afflicted and dealing with schizophrenia here in California. And so there was a concern that the floodgates would come wide open and we wouldn't be able to handle the onslaught of petitions that would come our way. And as I'll share with you later on in this presentation, that actually is not the case. And again, those of you who deal with this population, you know this population well. And simply because somebody files a petition isn't going to cause them to come to court or reach out for voluntary services or actually interact with those services. Um, so what we want to make sure, as I indicated early on, we want to protect that self-determination and civil liberties by providing them counsel and always having support people present with them during the proceedings. And more importantly than anything else is we want to be able to intervene earlier so that we can intercept folks so that they don't penetrate into my criminal justice system. Too often, there are so many mentally ill people incarcerated, and we want to have them have their treatment without being incarcerated or fall into the criminal justice system. So this was a plan and a hope by the administration and those who created the legislation to address a very specific subset of our mental health population and hope to intervene and protect them from moving into the criminal justice system. So what did we do when we knew it was chaptered and we knew we were part of the cohort 1 community? We started forming meetings, sometimes twice a week, but at least weekly for months going into the implementation, which was bringing our county stakeholder partners together. We made sure that we kept track. We had markers of dates, we had guidelines, we had timelines, and all focusing on what it was going to look like as far as being access for these participants. We modeled it after many of our collaborative treatment courts, making sure that there was always going to be legal support and self-services for supportive decision-making. And of course, proactive community outreach and education we knew was going to be key, specifically messaging what that CARE Act was going to be and not be. So we had a tremendous amount of feedback from our folks at the town hall meetings. And primarily these were family members and friends of those who were, quite frankly, at their wits' end and didn't know what else to do because time after time their loved one was living on the streets, was not engaged in services, was not getting treatment, and they wanted an answer. They were without a home. And again, what we had to remind them is this is not your answer to homelessness, but what we want to do is we want to touch these people's lives and bring them into voluntary services. Again, making sure the people who are at the table understand the population that we're serving, which again is simply because a petition is filed doesn't mean that they are going to immediately engage in services. And in fact, as you all know, and myself included, sometimes it's taking 10 and 15 touches to build rapport with an individual. Sometimes that starts with going out into the parks, under the bridges, bringing them food, and bringing that rapport to the court and that trust so that they know we want to assist them. We want to help them. We want to intervene earlier. Just a little bit about criteria. As I told you, it's very, very specific. And here, as you'll see on my slides, the criteria for participation in our CARE Act is to be 18 years or older, currently experience severe mental illness and has a diagnosis of schizophrenia spectrum disorder or related psychotic disorders, not clinically stable in an ongoing voluntary treatment, and one of the following is true: that they're unlikely to survive safely in their community without supervision and substantially deteriorating. Number 2, in need of services to prevent relapse that would likely result in grave disability or serious harm to the participant or others. Of course, what's really important, because again, this is a voluntary program, the CARE Court must be the least restrictive option to ensure recovery and stability. So what we're also seeing is a tremendous amount of contact that had not been seen before, and engaging folks voluntarily and basically off-ramping them to other services without actually bringing them in to the court with a filing of a petition where a judge is making a prima facie determination. And for us, we see that as a huge success. And in fact, what we're hoping is seeing those who will capture data, and there are tremendous data components within this legislation, and this time period just isn't enough to go into all of the components of the legislation. But what I will tell you is we are very proud if we can contact an individual and connect them to services without having them be brought to court, involved in a court care plan or agreement. that's a tremendous win for everybody involved and the family members, and get them services, including potential housing, right? So we want to make sure that our participants will actually benefit from their participation in the CARE Act and the care plan before the court. Some of the things that were asked of us very quickly in our town hall meetings and what we make sure we're educating on is what is not eligible for participation at this point in the CARE Act. And I'll discuss at the end of this session some of the things that we've seen that we would like to see changed perhaps in the legislation and the issues that we're seeing coming up. But we have many who say there are so many other disorders that need to be included in this act. And right now, the way the legislation is written, it's very specific to schizophrenia or psychotic conditions and severe mental illness. We've had many ask us, what about TBI? What about autism, dementia, or those that are causing substance abuse disorders that are causing psychosis? I know you have some significant sessions during this conference about psychosis and as it's related to substance use disorders, those are not eligible for our participation in the CARE Act as it's drafted right now. When we talk about who will be the involved parties, there's the petitioner and the respondent. The petitioner is very important and key in this legislation in that when it was created, many of our other treatment programs, assisted outpatient treatment, Laura's Law, for instance, had a very limited qualification of who could file a petition. What we realized is the family members, and I'll share with you just in a little bit, others who can actually file a petition. It was key to make sure that the loved ones, people involved in the participant's life, could file a petition. The respondent obviously is your participant who will participate in the CARE Act program. And of course, there is a CARE court judge who oversees the programming. This is important because, again, we find that often folks coming into a court, if the court convenes the parties and brings them together, there's movement, even if it's voluntary movement, that you would have that perhaps you wouldn't have if you were out in the general population. So sometimes just the effect, and I think they call it the black robe effect, but it's very true, having a judicial officer who is bringing all these parties together, including oversight on the services, the programming, the behavioral health partners, brings an additional layer of credibility to the programming. And we're seeing some success with that. When we talk about the petitioner not being our county or a county behavioral health agency, it is important to note once the petition is filed by somebody other than a behavioral health practitioner, a prima facie hearing is conducted. If the judicial officer finds prima facie, they will relieve the petitioner and appoint the county behavioral health agency as the substituted petitioner, and that's found under our WIC code 5977. As I indicated to you, county behavioral health plays a very large role in this for obvious reasons. We also have the public defender who represents the respondent in our county, but there are other counties in the state of California that will have other affiliate law agencies or services, public law centers and such that will represent the participants or the respondent. Also in our county, the county council, we refer to them as COCO, are the agency that represents the county agency, aka our behavioral health agency. So I spoke to you just a little bit about, well, who can file a petition and why that's so important, because it was exclusive in some of the other filings that you see with conservatorships, with, as I indicated, our assisted outpatient program or treatment program. Here, this is going to allow parents, siblings, spouses, grandparents, boyfriends and girlfriends, lifelong boyfriends and girlfriends we're finding. And again, overseeing those petitions, the judge will obviously look at that petition, take a review of all of the criteria that's required under the statute and make a determination whether there's prima facie evidence to move forward. Of course, directors of a hospital can file these petitions, especially when the respondent has been hospitalized, including on a 5150 or a 5250. Directors of public or charitable organizations, agencies, or homes where the respondent has resided within the last 30 days. And of course, those healthcare providers are also petition filers for us. Licensed behavioral health professionals, and first responders. And this first responder was a key also, ladies and gentlemen, because what we were seeing is often police agencies have homeless outreach or mental health outreach that know this population well. And it's an opportunity when they have had contact in building that rapport to be able to file the petition and identify those who would best be served perhaps by this additional support through the CARE program and identifying them as fulfilling the criteria that's set forth in our legislation. Obviously listing the rest of the agencies that also can file petitions through our public guardian, adult protective services, of course, the county behavioral health practitioners, our Indian Health Services program, and of course, a judge or a judge of a tribal court as well. This is also important right here is in our misdemeanors. Right now, if a misdemeanor is found ineligible for diversion under one of our penal code sections, PC 1036, the court can refer that defendant to the CARE program. And we've instituted processes within our own court, and I know the other cohort 1 counties have done so as well. If I hadn't mentioned the rest of the counties, so all 58 counties will become cohort 1 and cohort 2 counties and are required to implement the CARE Act by the end of this year. So by December of 2024, all 58 counties in California will have stand-up programs running for the CARE Act. The other part I would like to bring your attention to is the respondent themselves can file a petition. And we've actually been seeing that here in Orange County where it's happening while they're incarcerated. And of course, I'm sure they're being assisted by their public defender or their defense counsel, but we have received numerous petitions from those who are actively incarcerated looking for alternatives and off-ramps, which is clearly what we're hoping to see with this program and the success of this programs. So we've been bringing in petitions that have been filed from a defendant to become a respondent and hopefully downgrade them or step them out of the criminal justice system and potentially into this CARE Act program. Something that's very important that we also shared with our community and we continue to with our outreach regarding what are the respondents' rights. First of all, they receive notice of all their CARE court proceedings. And of course, as I said early on in this session, simply because a petition has been filed doesn't mean that that respondent, that individual is ready to accept services, voluntary services. Sometimes it's going to take many contacts, and that's either from their counsel, the social workers working with counsel, the behavioral health professionals that have been assigned, reaching out to them where they're at in the community, and hopefully being able to bring them in and then offer them services, housing, wrap services, whatever would be appropriate, again, under the least restrictive means as possible. They, of course, will receive the copy of all the court-initiated documents and evaluations. They do have counsel appointed and will have counsel appointed. A separate supporter, separate from their lawyer, will be appointed with them and present at all their hearings. They have the right, as in any other proceedings, to present evidence at those hearings, call witnesses to testify, and cross-examine any witnesses against them. And of course, there's full appellate processes that will be attached to any of these hearings. Talking just a little bit more about who is eligible, what the petition should include. Of course, there will be very specific criteria as to their diagnosis, whether or not they have been in inpatient treatment and had episodes within the last 60 days. The court does review those petitions. And of course, the court is working very collaboratively with our behavioral health providers to assess the petitions, to review the documentation that's attached to them, because this is including a lot of medical information and mental health documentation that we will go through. And ultimately, what we want to make sure is, are we bringing in the correct individual? If that prima facie determination is made, it's set for an appearance within 14 days. And again, When we talk about the 14 days, that's a very quick turnaround, as all of you know as practitioners, to do a full assessment and provide that information back to the court. What we're seeing early on in the first 6 months, that 14 days certainly is not enough to engage with a particular participant, and certainly not enough to get a full assessment back to the court. So we are seeing continuations that are agreed by all parties and in the best interest to then create, whether it's a care agreement or care plan, or a diversion out completely if there are involuntary services and are not in need of a care agreement or a care plan. We talk about the stabilization on their medication and any antipsychotic medications to reduce those symptoms. But we want folks to remember these cannot be ordered involuntarily or forcibly administered. This is a voluntary program. And furthermore, that the respondent or the participant in this program cannot be penalized for a failure to comply with their medication order. Of course, what we want to make sure we're doing is providing a housing plan, as the housing component was such an important piece of this legislation. But again, as I shared with you at the onset, this is not the solution to the homeless issue and crisis, which we are, I think, all confronted with, certainly here in California. But we also want to make sure we have other support services in place. It is developed through our behavioral health community as well as with the respondent. So it's important to note this is a collaborative effort from the very beginning through all of the phasing and ultimately through to their graduation or successful completion of the program. Ultimately, once the care the care plan or agreement is put in place, the elements of that plan will be approved by the court and adopted via our court orders. Again, this is one of the slides I just like to talk about, bullet points that we share with our community, that what is a care agreement or plan. It contains behavioral health services, medication management, housing resources, and obviously those WRAP or social service supports. And all of it is voluntary. It is something that we really want to continue to emphasize. So what's the accountability piece? Why? Why is there a need for accountability? The legislation that came down on this was very specific. Because of the court oversight, the judicial oversight, there are clauses within this legislation that say if the court finds that the county agency or local agency is not complying with the directives or plans, that the court can impose $1,000 a day and up to $25,000 per violations. That money would then be directed back into funds to be distributed to local agencies to help with further services. But again, we want to be really mindful of the collaborative nature and being realistic, teeing off with one of our local agencies up front to say, my goodness, you didn't comply with that first order, so I'm going to fine you thousands of dollars, is probably not going to work for the productive relationship. We have not seen this aspect. Again, we're 6 months into the program, but this is part of the legislation. Obviously, with respect to the accountability as to the respondent who's involved, the court can terminate participation if the respondent is not participating in the process. And of course, there are appellate rights, notice in the presumptions that are contained within the legislative language. We don't want to terminate. What we want to do is continue working with the parties, the participants, for the best possible outcome. But there are those clauses for termination if appropriate. As I shared with you, obviously, there's court termination if appropriate, but the plan we really want to see happen is the graduation plan with the agreement to support transition out of the care court. And that may include, and this was important, a psychiatric advance directive. However, those are not enforceable by this court, but it's something that, as we all know, is important as we move forward. We can extend a participant in the program. The respondent themselves can ask for up to an additional year of care court. And of course, the court can order involuntary reappointment, but only for up to 1 year. When I first started, I said, look, we're working together we're seeing that there are challenges in this legislation. We're seeing that there are really positive outcomes. And I shouldn't abbreviate it. AOT is our Assisted Outpatient Treatment Program. That's under Laura's Law here in California, and that is an outpatient treatment program. We did a lot of modeling after that program when we created the infrastructure, creating all the rules, the forms, the petitions for this particular act. So there was some mirroring of what was going on. We also have been working with our DRC, which is the Disability Rights of California, and they are advocates on behalf of those mental health patients for us. And we want to make sure we continue with our communication with all of the advocates on their behalf so that we're getting information where they're concerned. We know that the days available to us for the implementation of this program are limited. And what I mean by that is the fact that we have it here in Orange County 1 day a week. As the petitions grow, as we get more, we would like to be able to expand. But we're also very cognizant of fiscal constraints and budget cuts that are coming up for California here this year that will have impact on court operations and core functions. And of course, I think every single county is going to tell you the availability of appropriate housing for our participants, for any of our participants in our treatment programs, is not where it should be and where we would like to see it be. And that's an issue that all of us are really working to work through. Concluding with some of our strengths and challenges that I've spoken to, we want to make sure that this is accessible in all of our justice centers, which means here in Orange County, I have 5 separate justice centers that geographically can accept petitions, has self-help available to family members, to friends, to respondents themselves to help them through the petitioning process and what it means. We have some legislation on board that's coming up that we're going to work through that has some impact on our conservatorships. But we're also, as I shared with you, we're working through some of the unrealistic deadlines that we see on making contact assessments, evaluations, and returning those to the court and building the rapport that I talked about, that it's going to need more than 14 days. Also, the fee waiver, I think we've overcome the fee waivers as we've made sure that we're not charging those folks for the filing of petitions as many court proceedings are required. So that was actually built into the legislation and some trailer bill language. We're also working on mandates and directives to the private insurers to make sure that they are covering this for families who do have insurance, and to be able to make sure that the coverage is in place and that they're not getting declined. What we'll tell you is, as I shared with you early on, we're hearing folks want expansion beyond the schizophrenic spectrum disorder. They'd like to have us include whether it be bipolar disorders, whether it be the depression disorders. There are some other high risk, high needs populations that we think could be served by a model like this. And so I'm sure there will be further discussion on that. And what I'll talk to you about those actual numbers is, it was projected that I believe there's about 12,000 folks in California that would potentially be eligible who are known to have schizophrenic diagnosis at one point or another. The numbers are actually much, much smaller that we're seeing as far as actual petitioning coming in. So the floodgate that I told you folks were concerned about has not come to fruition. So we're seeing not a trickling in, but we're seeing petitions being filed, but not at a rate that was overwhelming for us to handle as we stood up this program. So what I want to leave you with is just some resources for any of you if you're interested. Of course, any of us in the Cohort 1 counties, we are helping our Cohort 2 counties come on board, but our Judicial Council through California has actually a tremendous amount of resources, a dedicated hub and website to the CARE Act. I've listed the contact folks in our Judicial Council Center who are the point people. And as you'll see, the website as far as our courts.california.gov adult civil mental health page, which includes the CARE Act resources. So that is what I'd like to provide to you in a very short amount of time. Again, I I went through it very quickly. I know that. I'm always open if you'd like to reach out to me. My contact information is with the conference's website. Please, thank you. Know how grateful I am for you allowing me to be here as a part of this conference, and the work that you're doing is so incredibly important in how we address our communities. So thank you very much.